I like to have my back to you all the time, Michael. I'm sorry.
Okay, thank you. Welcome everybody to this first City Planning Committee meeting for 2021. We have in attendance in person Alderman Briscoe, Councillor Harvey, Alderman Barakis, Councillor Coates, myself, and Councillor Mike Dutta is zooming in. Welcome, Mike, Councillor Dutta. So no apologies nor leave of absence. No reason to co-opt because we have a full committee. Item 2 is confirmation of minutes from the last meetings. Thank you, Alderman Barakis. Those in favour? Those against? Items carried. Item 3 is consideration of consideration of supplementary items. No supplementaries. Item 4 is there any pecuniary or conflicts of interest to declare? No conflicts. Item 5, transfer of agenda items. Any transfers? No. Okay. Item 6, planning authority items, considerations of items with deputations. Can I have somebody move that, please? Alderman Barakis, thank you. Those in favour? Those against? Items carried. So item 7, we're a committee's acting as a planning authority, and we're considering item 7.2.1, which is applications under the Hobart Interim Planning Scheme. And we have deputations online. So we have Dr. Rebecca Heath and Mr. Paul Tomaszewski. Who is to go? And Professor Pybus.
You need a motion, Chair, that we have that item first.
No, I think that it's fine. Thank you. I think we've done that we're hearing deputations, so that's fine. So I'll go to you, Dr. Heath, if you'd like to start. You have 5 minutes, unless you're presenting together. Just try again.
Oh, can you hear me now?
Yes, loud and clear.
Thank you for giving me the chance to make a deputation against this case of overdevelopment in Battery Point, which will have an enormous impact on us personally. The Capital City Strategic Plan 2015 to 2025, Strategic Objective 2.4, and the Interim Planning Guidelines recognise the unique contribution that Battery Point makes to Hobart, and arguably the state, and are explicit about the need to ensure that unique heritage assets are protected and celebrated. Building a bulky, modern and obtrusive wall behind the gateway entry to this heritage precinct presents a mockery of efforts to protect and preserve the core heritage values of the area. Amenity is considered throughout the planning scheme. It should therefore be considered in all cases, including those affecting the residents of the heritage precinct Battery Point. It's an incorrect interpretation that an area of such significance and heritage will need less protection and not have the benefits of the planning scheme as it is usually applied. Loss of amenity to our home will be really significant. Our house is split into 2 homes, 2 and 2A, and the loss of light and overshadowing affect both houses but profoundly affect 2A, where nearly all the natural light comes from where the development is planned. This is because it's an old sandstone home and carved into the natural slope. It's hard to describe how much amenity will be lost in respect to our family. As a young mum, I sit and breastfeed in our back room, and the loss of privacy will be hugely impactful in terms of our enjoyment. Our garden where our children will play will be both overshadowed and overlooked. Our vegetable garden will be shadowed and therefore not grow as well. The viewshed analysis provided by the developer is misleading as it's not taken from the most impactful areas, and it's from standing height of a higher than average sized adult. We sit in our back room, we don't stand, and we have small children who are clearly not adult height yet. But this isn't about views, it's about looking at a bulk form and being walled in by the development. Empress Towers are clearly an inappropriate development for the area and sit directly to our west, and with this development directly to our east, we're going to be potentially sandwiched between 2 large and inappropriate forms. This proposal highlights the need to meet performance criteria and impact of amenity on immediate neighbours, because those provisions that regulate heritage have no bearing and don't require consideration of how a proposal might impact amenity. We also have concerns about parking and waste management related to the increased scale of the development. We've experienced ongoing parking issues entering and exiting our home, which have been communicated on record with council for the last 2 years. The increased volume of residents and their visitors will exacerbate the existing parking issues unreasonably, and the proposed additional parking bays under the building are clearly inadequate, as they will also require reduction of the on-site parking that already exists. The existing on-site parking cannot coexist to allow vehicles to enter under the building to the new car parks proposed. As such, net vehicle parking gain is either unlikely or very limited. Waste management of the property includes all the property council bins remaining visible on the curbside at Castries Esplanade for the past 4 years. The additional residential units will only exacerbate this issue and result in more bins being left on the nature strip at all times in constant view. The current proposal does not sufficiently remedy the current practices of leaving bins along the road at all times, or the management of the waste that we created if the development were to go ahead. As the property is itself not heritage listed and not in keeping, it appears that officers are taking the view that heritage impacts are negligible. However, they are using the heritage planning scheme to determine whether development should be approved. The property is clearly out of keeping with the values that Hobart Council are seeking to protect, and any additional development of this as an out-of-keeping site not only detracts from the heritage precinct, but critically, currently ignores amenity considerations. It surely cannot be the planning committee's intention that neighbours in heritage precincts are not protected by consideration of amenity like other areas of Hobart. Amenity considerations are central to any and all other development applications in areas that are less protected due to their lack of heritage. I thank you for listening and hope that you're able to advocate that the planning scheme be interpreted correctly and amenity be rightly and appropriately considered in this case, and therefore the developer's application should be rejected. Thank you.
Thank you very much. And I'll go around the room. Are there any questions? Any questions? Councillor Dutta, do you have any questions?
No, thank you.
Just, Dr. Heath, just in relation to your boundary, what sort of overlooking are you expecting there might be?
It'll look directly into our main living space and the 2A downstairs main living space, and then the whole of our garden. And
so the second part of your property, so there are 2 properties on the one title, so how do they configure?
The house is sort of got 2 self-contained units, so for an older, less able-bodied parent downstairs, it's all on one level, so it's got its own kitchen and bathroom and bedroom, and that's directly onto the street level, but of course the hill goes up, and then we've got the second part of the property, the level that we're on, normally a bit more mobile, where we've got, again, same like living space, so kitchen, bathroom, and living space. So it's completely, you could divide it, although there are internal stairs.
So upstairs and downstairs are quite separate?
Yeah, they're completely...
Yeah, okay, thank you. So if there are no further questions, we'll go on to you, Mr. Tomaszewski. So you have 5 minutes to address, and if there are different points, that would be useful. Thank you.
Thank you for giving me the time to talk to you today. I address you and ask you that you appropriately use your discretion as elected members to ensure that amenity considerations are appropriately considered within the Heritage Precinct. My wife and I live with our 4-week-old baby in 2 Hampton Road. This home shares its entire rear boundary with the proposed development at 2 Castries Esplanade. My wife, I must say, has also been incredibly unwell recently, and we've spent the last two of the past 4 weeks in hospital. And as new parents, as you might well understand, we're pretty exhausted, and this is the last thing that we want to be doing, but it matters to us greatly. We ask this committee of elected members to use their discretion to not allow this incredibly impactful proposed development to go ahead due to the enormous and unreasonable impact on amenity that the proposal has on all of the neighbouring properties. This committee can consider these amenity issues and act to ensure that developments such as these are not simply rubber stamped. Importantly, we are not against the adaptive use of the building itself, rather that due to the proposal's density, form and consequent impact, our enjoyment of our property will be significantly reduced. The building at 2 Castray in its current form sits within the Battery Point precinct. The building is not in keeping in terms of formal function. From the entire rear of our property, we see a 2 to 3 story high wall across the length of the property boundary. Above the current wall, we get some sense of light and some sense of openness. Our entire house is orientated towards the rear of the property, as it was originally built as a shipbuilder's property to overlook the shipbuilding yard, which once stood at 2 Castray Esplanade. This orientation is aimed at maximising connection to the river and access to the sun, having stood this way since 1846. The existing building at 2 Castray removes much of the connection that was originally in place. However, the proposed development removes this connection to river and sun and openness entirely. Rather than address these issues with the existing structure, the developer is seeking to expand the bulk, dominance and density of the existing building. The proposed expansion of the building has the effect of increasing density, reducing privacy, reducing access to sunlight, as well as increasing the dominance of a building that is already not in keeping with the elements that are intended to be preserved and celebrated in the precinct. Rather than address the impact of the existing building, the proposed development completes the full walling in of our property by adding another story, black bulk, as well as extending the bulk beyond the length of the property. Our outdoor space and garden would no longer be a private outdoor space, rather it would be overlooked, enclosed and shadowed by a 3-story solid wall. 7.5 of the Council Officer's report in relation to building envelope outlines that the current assessment was completed consistent with the Tribunal's approach. However, this Council has the capacity, indeed it is the time, to revisit the consequence of this view. One of the reasons that it is the time to revisit this view is that the consequence of the decision that this Council made in respect to the development of Montgomery Court, in which this Council made a different decision to the recommendations of its planning officers and voted to refuse a development because of amenity impacts on neighbours despite planning officer approval. This Council made that decision at a time where the standard approach based upon tribunal decisions where regard could be had to permitted development when assessing discretionary performance criteria were in place. Council has been right before in going against the advice of officers, particularly as matters pertain to amenity impact development. And we ask that you rightly ensure that amenity impact on immediate neighbours are considered adequately as part of the assessment of this development. It is clear that this proposal highlights the need for assessment of all Battery Point developments as they relate to performance criteria, specifically in relation to bulk and scale and consequent impact on the amenity of immediate neighbours. Those provisions that regulate heritage have no bearing at all on these amenity issues and aren't considered currently. This committee has the capacity and discretionary powers to make these considerations today, as this Council did in relation to the proposed development at Montgomery Court. The specific discretions relate to the form of the building itself, its ability to receive sunlight, and its overall density, as well as the consequent and enormous impacts that the development has on us and our home. These are listed in 6.5 of the Officer's report, and we consequently ask the elected members here today to exercise your discretion to refuse this proposal.
Thank you. Any questions? Councillor Dutta, do you have questions?
Thank you, Chair. Just one question. I'm in a room where there's a lot of very heavy rain, and so I'm not able to hear very clearly. Just a question with regards to amenity that was mentioned. What amenity are you referring to, and which particular performance criteria is not satisfied?
It's in relation to 11.4.2 performance criteria 3, and that relates to the siting and scale of the proposal, which unreasonably impacts on effectively what we can and cannot see. So that includes loss of amenity, including, so performance criteria 3 states the siting and scale of the development must not cause unreasonable loss of amenity by reduction in sunlight to the habitable room, other than a bedroom or dwelling, overshadowing the private open space of the dwelling on an adjoining lot, or overshadowing this place to an adjoining vacant lot, and visual impacts and all the apparent scale of the portions of the dwelling when viewed on an adjoining lot. So all of those criteria. Effectively, the wall extends the complete length of it actually extends over the length of our rear boundary, and the intention is that the proposal is intending to go up an additional story on top of the minimum of 2 stories that we currently look at for a solid brick wall. They're intending to go up an additional story plus expand on the southern side, expand increase the height of main section on that building. Approximately 3 stories in addition to what's currently there. So again, it's expansive, and that is extending beyond the scope of our property. But the impact is significant.
Any further questions, Councillor Dutta?
Thank you, Chair.
Are there further questions around the table? No questions? So I'm again going back to this wall. So in effect, you have. I'm not quite sure of the length of the wall now. No, but it will be extended further, and of course that part of the wall will be going up to meet the next height of it. So it will be quite solid from your perspective. From what you've seen, yep. Okay, I see.
As a guide, I'd be just as a guesstimate. The current wall is probably 30 metres in length, and the extension is another 3 to 4 metres on the southerly side, from memory.
Right, thank you. Okay, well, thank you very much. We'll now go to our next deputation from Professor Pybus. So you have 5 minutes to address the committee, and you're acting or speaking on behalf of the unit complex at 10 Finlay Street, are those people who put in representations?
Right. I myself did put in a representation of where I was travelling at the time. Apparently it didn't get logged, but it's essentially the same representation as I would make on behalf of my fellow residents of 10 Finlay Street. I really appreciate having this opportunity to speak for you from distant regional Victoria. I'm flying blind a little bit, but I have a very clear idea about what it is that concerns myself and my fellow residents. That is that, first of all, we're concerned and puzzled that a previous application for visitor accommodation, which is identical to this one, except for the specification that it is visitor accommodation, has still not been resolved, and that we are now considering another application, identical, for an identical building. And it is not clear to us whether this is for specifically not going to be visitor accommodation, and whether or not, if the appeal against the previous application is upheld, where does that leave this particular application? Does it then mean that the previous visitor accommodation is going to be approved and developed? That's a kind of concern that we have. There's a concern about the process that has allowed a second application to come before the planning committee before the previous application has been completely resolved one way or the other. Now, I may be misunderstanding about that. I've been out of contact, I've been travelling. This may have been resolved, but that has been an issue. I entirely agree with what Paul and Rebecca have all previously said about the question of amenity. This proposal will impact me and my neighbours by overshadowing us in a way that is not the case with the current building. There is an extension on the end of the building that will overlook and look directly into our properties, overshadow and overlook. That especially the swimming pool that is proposed and that this will impact considerably on our sense of privacy and our sense of privacy and our sense of enjoyment of the space that we have. All of us are retired elderly people who have lived there for some time and have and consider this to be not just our home, but the place that we spend, you know, the bulk of our lives, and the place that we intend to spend the rest of our lives. And that this is really very distressing to us, that we're going to have something that at the moment is basically not impacting on us quite as much, because what is proposed for our end of that building is that it goes up the equivalent of 3 stories. As well as the additional story, it's actually raising the level of the building and therefore the intrusion of, in the case of a swimming pool, you know, an area of recreation, immediately overlooking our bedrooms and our small balconies, which is where we basically spend our time, day and night. And so there's that issue that is of causing considerable distress to myself and my neighbours. The building itself is inconsistent. I'm sure everybody would agree the building itself as it stands, an industrial building which has no heritage value, is an eyesore. It is not appropriate to the rest of the suburb. It does it in terms of its mass, in terms of its bulk, in terms of its height as it stands. It is not appropriate for the suburb of Battery Point, the precinct of Battery Point, to put another story on the top of it, which would be luxury apartments with a swimming pool on one end and another entertainment space on the other end. Is not going to in any way make that building more appropriate. It will make it less appropriate. It will increase its bulk, it will increase its height, and it certainly won't do anything to improve the look of it. It is not appropriate in Battery Point.
Would you like to sum up? Your 5 minutes is almost up.
I understand. Thank you for reminding me. I think these are the things we haven't consulted planning. We haven't consulted lawyers. We haven't consulted planning officials. We're just speaking from the heart here. That this is, there's a lot of angst about what is going to happen to what has been our homes and the homes that we will die in. If this development goes ahead, because it will seriously impact on us. I mean, in the case of Barry, who is not able to be here, it will look directly into his bedroom, directly down on his patio, and it will look directly into my bedroom also, and my patio.
Okay.
I don't want to live in a situation where I have to have the blinds drawn in my bedroom, which is also a sitting room for me. I don't want to be in a situation where I go out onto my balcony and I'm overlooked by people who are having drinks around the swimming pool. I don't believe that a 3-bedroom apartment with a swimming pool is necessarily appropriate for the village of Battery Point.
Okay, all right, thank you. I'll see if there are any questions. Any questions from around the table? Councillor Dutta, do you have any questions?
No, thank you, Chair. Thank you very much.
No, I don't have any questions of you, but we might get Ms Aby just to explain exactly the situation with the previous action and also where the other application rests.
Thank you. The earlier application was for exactly the same built form but with different use of visitor accommodation. That application was determined by the council as an approval. It was determined at officer level due to timeframes. That was subsequently appealed, and the tribunal supported the council's decision and directed that the permit stand. That decision was then appealed on technical grounds relating to the visitor accommodation use, and Professor Pybus is right in that those Supreme Court proceedings have not yet resolved. So the initial application is to some extent still up in the air. A possible outcome is that there will be one permit for visitor accommodation and the built form from the earlier application, and this later application could potentially also be approved, but with a different residential use.
So in essence, you can have more than one development application for the same property.
That's correct. Of course, the visitor accommodation use would have to have been substantially commenced within the 2 years. So they wouldn't necessarily run side by side. One of the uses would have to be commenced in order for that permit to be relied on going forwards.
Thank you. I hope that explains some of it to you.
It explains what I understand to be the case.
Yes.
Does not explain that we are now considering one proposal when another proposal can be granted a permission in the near future and start acting on that for visitor accommodation.
Yes, yeah, I understand that. Okay, so
been able to be exempted from the situation where within the precinct of Battery Point, standalone visitor accommodation is not permitted.
Okay. All right. Thank you. I'll now ask the applicant, Mr. Michael Cooper, and you're just alone, Mr. Cooper?
Yes.
Oh, all right. Do you want to come up to the table as well?
Okay.
Yep. That's
I've actually
fine.
got some images which I'll get someone to pass them round. And what I'll do is I'll just start off. If I talk to them, I'll hand them around because you need to look fairly closely. But this journey itself has been going for 2 years. We brought the property back in 2018, and the property itself originally started as the Port Huon fruit juice factory. So that's actually the property there. You can see there, it originally had a story on the roof. That story there was there till 1977. It was removed in 1977. The height of that additional story was 4.5 metres. So our application is to put 2 apartments on top, which go to about 2.3. During the process, early days, when we put our first application in, we'd worked with the council alongside the design and the bulk of the building and decided to make some changes to the building, which we did. We also seek mediation with our neighbours, Beck and Paul, and another neighbour which is currently not on the screen. We offered to reduce the height of the building and also shave off a corner of the southern end, which I think Paul mentioned as well. So the wall was offered to be shaved. They rejected our mediation and said, we'll see you in the tribunal. We then went to the tribunal and we were successful. After obviously the council gave us a DA. I'll go back a bit. When in the council's DA that they gave us approval, there is screening in the DA that has to go along the back wall. So we literally cannot see into Beck and Paul's backyard. There's proper screen there. It's actually on the approved plans. And also, we don't want to see into Beck and Paul's backyard. There's high-level windows in the apartments at the back, which, unless you stood on top of a ladder, you wouldn't be able to see through them. You'd be looking into a screen. So I'm not sure if you had a chance to look in the detail of the plans, but that protects that. We're about 16 or 17 metres away from Beck and Paul, so we do comply to that distance in the planning scheme as well. So the built form has been tested and has been approved. Heritage was tested really in depth as well. Obviously, Sarah is involved in that on the council side. The council have been supporting us all the way through. We've both had experts. We had 3 heritage experts as well, and we had a planning expert as well along the journey. So we put significant resources, along with the councils, put significant resources along this journey. The council invested heavily after the last 2 years and supported us during the process. The building is in a residential zone. So all we're asking is that it complies to its inner residential, which we're asking it to be for this approval. The precinct originally, and I'll pass these around a bit, was very, very heavily industrial. We spent a lot of time and effort trying to research the history of the area. That is the actual factory sitting down below the actual building. So that goes over all John White Park. So that's it there, which I'll pass around. So it's a very, very heavy industrial space. This here is the waterfront apartments, which you'd all know about when you drive along Hampton Road. That's actually the actual cool rooms. They were the original cool rooms which were converted to the apartments. So as you can see, there was bulk, ugly bulk, that was converted during this whole project of this building. This was actually the head office for Huon Fruit Juices, along with the additional scope on top. What we also did on request of the council was to take got some montages done from all different angles, which were quite important angles for the public, for people walking past. That's the one that you cannot, the building is actually imposed, but you can't see it because it's down below the wall. That's walking along the street, and that's the standard person. That's not a giant. This one here is looking down. From the park, basically from Princes Park, that one there, you'll see that one there, so you can actually see the building in black down the bottom, so you can hardly see the building. This one here is from going up Castro Esplanade, as you can see, so once again, you can't see the building, it's well hidden. We've recently had the building repainted. It was a yucky creamy colour, and we recently had it painted like a dark grey, cold grey, which makes it disappear. This one here is a really good one to actually have a look at, and I'll point out this fact is that the actual neighbours can clearly see over the top of the roof. This is probably done by 3D images and stuff, and been actually measured out by geoscience as well, so they're actually very accurate. You can actually see the neighbour's house behind, and you can clearly see the windows, so they can clearly see over the top of the building. I think it's, for us, we're a mum and dad as well, and we've got family, we fully respect that. Screening and privacy is very important for us as well, so we fully respect our neighbours, and if they would like more screening put up, if they're not comfortable, we're more than happy to do that. We always wanted to work with them. We tried to work with them initially, and they rejected it. The comment regarding the swimming pool, the actual swimming pool is not on the end of the building, it's actually inside, it's inserted in the building. It's about actually 6 metres from the end of the building, so there's no way that we could see down to 10 Finlay Street. You can't...
To sum up, please.
Yep, I was just coming towards the end.
Yep.
I just want to say that along the whole journey, we've actually been 3 times that we've had approval granted, and we're just asking that the committee tonight approve along with their support, which they've done all the way along. Thank you.
Thank you. I'm sure there'll be questions, so that we'll get more of your answer. We'll start with you, Alderman Briscoe.
Yes, look, I do believe, in reading the report, I got the feeling that it's essentially the same application, except you've taken away visitor accommodation as a...
That's correct.
So this council has approved it once.
Yes.
It's been accepted by the tribunal.
Yes.
And on a technicality, whether visitor accommodation is allowed there, is still in front of the Supreme Court.
Yeah, we won the Supreme Court, and then our neighbour's lawyer wants to bring some more evidence, so they've asked Justice Lowe to reopen it. He's still deciding whether he'll reopen it. He hasn't made that decision yet.
Right. Okay. Thank you.
So I would just like to add to that the built form itself has been through fairly rigorous judgment and investigation, and that it does fit the planning scheme. As we understand it, and the only issue here for tonight was its use.
Alderman Barakis.
Thank you very much. Just to clarify your answer to Alderman Briscoe, so the most recent Supreme Court decision was that the built form and everything, the approval of that should stand.
Yes, correct.
And the amenities.
So you can go ahead and build it. It's looking to be right use.
Further questions? Councillor Harvey.
So if the judge decides to, what's the term, reopen it or re-look at it, what happens then?
What we understand is they just have a hearing, so the lawyers have to bring all their papers together again and write up all their evidence again. We'll be obviously submitting the same evidence we've done before, and the other guys will be submitting what new evidence they think they've found. We're not sure where the amenities thing has come from, because we had a four-day tribunal hearing where the amenities were actually discussed, and it wasn't brought up as an issue by the tribunal, mainly because of the distance away from the 2 houses and 2 properties.
So the 2 applications, through you, Chair, confused of what might happen if it's reopened in regard to the DA here tonight, if it's approved. And I guess that's a question for you later, maybe. I don't understand. If they did reopen it,
Yes.
would that put this DA on hold, or?
No, from what we understand is, and I'm not a lawyer, Karen might be able to help us out here, but from what we understand is this is a separate DA. So this one, if we are successful with this one, it goes ahead as residential. The visitors accommodation still sits off to the side.
Okay.
And I believe that, and tell me if I'm wrong here, Karen, that once you have visitors accommodation, you can always get residential. If you've got residential, you can't go backwards because the planning scheme changed in 2018, July 1, I think it did, where Airbnbs or visitor accommodation was reduced in Battery Point from being a standalone to small rooms, I think, or...
So the one that could be reopened again is with regard to visitor accommodation?
That's correct, yes. Yes.
Do you want to add anything, Ms Ovey?
No, I think we've all arrived at the point where we understand there are two separate applications. They stand alone, and either one could be built and the use commence.
Okay, thank you. Councillor Dutta, do you have any questions?
Just a question. With regards to the previous speakers, they expressed a very deep concern with regards to shadowing and also invasion of privacy. You may have stated or commented on that, but I couldn't hear very clearly. Would you be able to comment on that particular points, please?
Yes, Mr. Dutta. Basically, Pip and I, we're very concerned about privacy as well, so we will do whatever we can in all our powers to make sure that privacy is addressed. In the DA that has been approved by the council, there was additional privacy screening put along the back wall which faces the neighbours which we're talking about. So that is actually our mandate, to make sure there is privacy for both sides. As far as the shadowing going, we've never got to that level of overshadowing because it was only 2.3 metres above the existing building. Considering there was a property that was 4.5 metres, the neighbour's house was built in 1946, I think, something like that. 18, was it? Yeah, something like that. It was a long, it was a very, very old property. And that in 1977, the additional level was taken off the roof. So if there was overshadowing then, it would be a lot less than what it was.
I think that preceded the start of the planning scheme,
Yeah,
the
well,
planning
long time
scheme
ago.
before the current one.
Yep.
Councillor Harvey, you have another question?
A question in regard to the walkway. Come up in the lift or the stairs, and the walkway is at the rear. Is that an enclosed walkway?
Yes, that's one that has a screening down it, yes.
Mm-hmm.
Yep.
So it's open to the elements at all at the top?
No,
or?
the roof goes, screen goes like that, so it's fully enclosed.
Fully enclosed.
It's got holes in it for air, for ventilation, but it's enclosed.
Do you have any further questions, Councillor Dutta?
No, thank you, Chair. Thank you very much.
Okay. I just have a question just in relation to the bins. Where are you intending still to have them at the same spot, or?
No, it's interesting, the building itself, the rubbish bins, there's currently 3 tenants in the building, 3 office tenancies. There was 4, one has gone, and that would be replaced where the cars will go underneath, that's a tenancy.
Yep.
So there'll actually be less cars than what there currently is there today, so that offsets the traffic. The bins for the lower level, office blocks sit down the level, which is where our bins would be for the top. They wouldn't be out on the street. As you go past today, the ones on the street are for the top level office block.
Oh, I see. So they would be, so the bins...
So right down the bottom, they'd be in a slatted off wooden pick-up area. So they wouldn't be, you wouldn't be able to see them.
Is that a private collection, or is that council collection?
No, I think it's council. They're council bins, yes, definitely council.
All right, so you wouldn't mind if there was some advice in relation to that?
No problem. Happy to. They're ugly. Yeah.
All right. Okay, I think that's all the questions that I have as well. So if you'd like to resume your seats, unless there are any... Oh, Alderman Briscoe?
Oh, no.
If you'd like to resume your seats, thank you.
Thank you.
In the interest of the debate, look, I understand the concerns of the representatives. Look, I think for the question of debate, I think I will move the officer's recommendation.
Do you include that advice
Yes,
in relation to
the
bins?
bins, yeah.
further discussion or any questions of Ms Aby? I might add that Mr Noy declared an interest, so he's not in the room. Are there further discussion? Councillor Coates? Hello, Lord Mayor. We'll start with Councillor Coates.
A question through to Ms Aby. Obviously, and reading from the report, it mentions that obviously the applicant has a right to put in this application and we'll hear it. But in the instance that the other one does get reopened by the Justice, any decision that they make, I'm guessing if this was being appealed, would be able to reference his future decision if he decided to reopen it.
Through you, Chair. The two, as I said earlier, the two essentially will stand separately, albeit this is unusual in the sense that is the identical built form. So if this permit was approved and the proposal went ahead and was built and the dwellings were occupied as residences, and then the Supreme Court proceedings were resolved with the effect that the visitor accommodation use was approved, then that could they could switch from residential and then start relying on the visitor accommodation permit. I hope that answers your question.
It's quite confusing, and I might add that this application is before us. We have 13 representations, but tonight we have the delegated authority to make a decision because there hasn't been an increase in the expiry time, like an extension. So ordinarily this would be going to full council. Lord Mayor.
Thank you. I had to listen to some of the representations. I'm just a little bit confused about, this will now become a residence or several residences, but how will we be able to check if that's actually what is happening rather than visitor accommodation? Given it seems as though that was the original intent and purpose, and maybe this is all happening more to get approval rather than that there's any intended change of actual real use. Like how will we tell that, Ms Aby?
Through you, Chair. The enforcement team, which is headed by Ms Turner, conducts regular checks based on, for example, Airbnb listings or other internet advertising of properties listed for short-term use, such as visitor accommodation. And to be honest, we do tend to rely on neighbours passing on information where they think, for example, you know, the bins are always being put out in a certain way, or those sorts of little details which are noticed by people living in close proximity, and then further investigations would be taken by the enforcement team if that sort of concern was raised.
And how big is that enforcement team working to check on visitor accommodation compliance?
Through you, Chair, there's Ms Turner is the manager of the team. Rob McDougall conducts site visits and handles a lot of the practical side of enforcement. And Ms Turner is assisted by, I'd say, 2 other officers in terms of issuing enforcement notices or infringement notices, which are fines for breaches of the planning scheme. So essentially, if this property was built without a visitor accommodation approval and it was used in that way, then there would be a breach of the planning scheme, and there could be various types of enforcement action taken to ensure that that didn't continue.
Yeah, and how many sort of successful enforcements have we actually succeeded with in Battery Point for the use of, like in terms of investigations and successful resolutions or enforcements of the Battery Point rules?
Through you, Chair, because I don't work in the enforcement team, I'm not familiar with the intimate details of all of the enforcement actions, although I am aware from my time having worked as a solicitor that, again, as I mentioned, conduct that's mentioned by neighbours will be taken very seriously by the council and pursued, if necessary, through to a prosecution. There are times when this sort of conduct is reported and then the owner might realise that they can't continue with visitor accommodation. Then there's a solution such as the property is sold. But I'm sure there are.
You might take that on notice in that case. Any other questions, Lord Mayor?
Yeah, just the proponent talked about getting a lot of assistance from the council and the council staff. I mean, how do you, if you were a representative or a resident, and how would you, I guess, explain that in terms of feeling like there's a sort of, it's been procedurally fair?
Through you, Chair. My team works as much as with applicants as they require at the early stages. For example, we have our advice duty planner who's able to give on-the-spot assistance to people who ring up from day to day. There might be people who make a pre-application inquiry, which is a more considered application, and we will give them feedback on whether they meet the scheme requirements.
I think, sorry, just to interrupt, but I think they were talking about something a little bit, the impression they were giving was a lot of sort of hand-holding on the journey. So I'm just wondering what your, like for the representatives who might be feeling that they've kind of, the developer's kind of been given all sorts of assistance to basically get this up. What's your feedback?
Through you, Chair. While my team is happy and able to give assistance, by no means would they compromise their independence in the sense that they are championing for particular developers to do particular things. So while on the one hand they are open to giving frank and full feedback on a proposal, by no means are they sitting at their desks attempting to help applicants in that sense, trying to help them achieve things which otherwise shouldn't be achieved.
Right, thank you. Alderman Briscoe.
Yes, look, I'm worried about what the Lord Mayor has asked there. We've got an applicant here who's a well-respected architect and his wife. In good faith, there would be no way that they would do anything to break the law or break any planning conditions. So I feel that that inference should be withdrawn by the Lord Mayor. The inference that
Of order.
yeah, I suppose it is a point of order, but here we've got an applicant. We've got to treat all applicants in good faith. In this particular case, this applicant is in the industry with I have no knowledge of any wrongdoing by that applicant. But to infer that the applicant would purposely break any planning condition, I think is a reflection of this committee. So I would like you, Chair, to ask the Lord Mayor to withdraw that comment or that inference.
Alderman Briscoe, I think it was a question of the planning staff, but Lord Mayor, was that your intention?
Yeah, I won't withdraw it. It was a question to the planning staff about a comment I heard made by the proponent, and it was an open question. It wasn't a pointed question, and at no point was anyone asked whether they were breaking the law. No, I think that's
Lord Mayor. Further questions, Alderman Barakis.
Thank you, Chair. Look,
Discussion.
I suppose given that the Lord Mayor didn't withdraw those comments, I'll reflect on them in the context of this application.
Do you want to reflect on...
In the context of the application,
Okay,
Chair,
thank you.
Look, I don't think that it's in any way inappropriate for council staff to be working with applicants to be...
If you'd like to talk about the
Well, apologies, Chair. If it was appropriate to ask the question, it's appropriate to reflect on it.
Well, you don't have to. You can focus on the
I
DA.
don't tell me what I can and do and don't have to say.
Please, can we talk about the matter at hand?
The matter at hand is that yes, we have an application in front of us.
The development application is what we're discussing.
Yes, okay. So look, we have a development application in front of us that has previously been approved by this council, albeit under different usage, but the concerns that were, and look, I appreciate the concerns raised by the representatives, were all covered as far as the amenity, as far as the build form, as far as overshadowing, sunlight, heritage matters. It was approved by council. It was then taken to the appeals tribunal. The decision was upheld at the appeals tribunals. And then it went to the Supreme Court, and the most recent decision is that it was upheld there as well. The only difference here being that we're talking instead of, and apologies for that, we're talking, instead of visitor use, we're talking about residential use. But all of the issues that were raised by the representatives that we've heard from just then have all repeatedly been tested in council, in the appeals tribunal and the Supreme Court. And I'm happy to be corrected on that. But I think given that, and given that it's been tested by ourselves and as far as our panels senior to us, that the question is, if this goes to appeals tribunal, are we just entering into an exercise of redundancy? So look, I think that given that, and I suppose I'd only have one question, which might just further confuse things, but if both applications are eventually approved, it's up to the applicant to decide which one he chooses to exercise. Is that correct?
Through you, Chair, that is correct. The visitor accommodation use would need to be commenced so that permit has been activated essentially, and that use would, once that permit has been, comes into effect, then they would have those rights. If they did not commence the visitor accommodation use and that permit expired, they would lose those rights. And given the changes to visitor accommodation in Battery Point, they would no longer, I imagine, be able to obtain a later visitor accommodation permit.
Oh, okay. So, look, given all of that, I see no reason how, in the context of all of that, the decision or the recommendations by the officers is incorrect, and I see no reason to think that the appeals tribunal will come to a different decision to what they did last time. So I'd be supporting Alderman Briscoe's motion for approval.
Okay, thank you. Any further discussion? Councillor Dutta or Lord Mayor?
Thank you, Chair. I have three questions to ask. Question number one, tonight we are looking at the application number 2, if I can identify it as such, not the previous application. Is that correct?
Through you, Chair, yes, that's correct.
Thank you. Question number 2. With regards to parking, how many spaces are required?
Zabi?
Through you, Chair, excuse me.
So perhaps for the residential and the office accommodation, please.
Through you, Chair, the 2 spaces have been issued or proposed for the 2 dwellings, which satisfies the acceptable solution for the residential component. There are 2 parks proposed for the office use, which is deficient based on the planning scheme suggested numbers, although it is an improvement on the current parking, which is nil in the physical form. So to that extent, the parking on site is improved. The Senior Development Engineer has reviewed the parking requirements and recommended approval.
But how many?
Sorry, I'm just.
How many spaces is it deficient? Is it 20?
29.
29 or 22? Was it?
Okay, so just a clarification, the 20 spaces are required, is that correct?
I think it is actually, because it refers to 29 then previously.
Apologise, yes, that's correct.
Yes, 20.
So, let me get this clear, please. It is my clear understanding that there are 20 spaces required.
Through you, Chair, yes, that's correct.
Okay,
the planning scheme table suggests that there will be 20 spaces associated with the office use. There's no proposal to change the office use, but there is a proposal to change the built form and introduce 2 parking spaces.
So therefore, there are only 2 spaces provided, is that correct? Or 4 altogether?
Through you, Chair, yes, that's correct.
Thank you very much. I need to, now question number 3. Clause D1143P1 states that there should be a communal open space and public open space in close proximity. Could you please define the term close, and if there are any examples or cases that you can substantiate that with?
Through you, Chair. I apologise, Councillor Dudder, I don't have those definitions with me, although I'm mindful of the fact that the council officer has identified Princes Park, which is directly over the road from this proposal, along with the park, which is down by the waterfront, as the two accessible public open space which would be accessible for this proposal.
Well, that's a matter of discretion. There isn't an objective fact to say close definition is this.
I apologise, Councillor Dudder, I don't have that definition with me, no.
Okay, thank you very much.
Okay. Lord Mayor, do you have any questions?
Yes, I do. Look, I'm just wondering about the heritage side of things. The proponent talked about 3 different heritage experts had been, had a view on this, and I presume, Ms. Abbey, that our heritage team have said it's all fine as well. But I am, I'm kind of amused about that, because it is the entrance to the, the very significant heritage precinct suburb of Battery Point. And I know the existing building is not a beautiful building, but it's sort of, to make it higher and even more modern doesn't seem to improve the heritage precinct. Did the tribunal actually consider our heritage precinct provisions, or were they really just focused on the more of the Heritage Tasmania view of heritage, which is more about the actual property rather than the streetscape? And I mean, who was looking out for that sort of where it sits in the landscape, how it fits with the brand of Battery Point? Was somebody keeping an eye on that, or did that get adequately addressed by either heritage consultants and agreed to by the tribunal?
Do you want to answer this, or should I ask?
Answer at the
Ms. Abbey?
outset. Through you, Chair. So at the tribunal there were 4 heritage experts. So Ms. Waite, the Council's Senior Cultural Heritage Officer, Lucy Burke-Smith and Paul Lovell, who were all in support of the built form, and also Paul Davies, who was instructed by the neighbours and opposed the built form. And the tribunal consistently preferred the evidence of Ms. Waite, Ms. Burke-Smith and Mr. Lovell over Mr. Davies. The issues in the Hobart Interim Planning Scheme were thoroughly tested by the tribunal. This was not, the issues relating to the THC were not the focus of the appeal. It was squarely based on the Council's heritage provisions.
So they all thought that the streetscape precinct impacts were not a problem. That was...
Through you, Chair, the 3 heritage experts who supported the application were comfortable that this proposal was fell within the bounds of the scheme. Yes, that's correct.
Okay. All right. Any further questions? I have just Ms. Abbey, if you could just describe obviously there's concern about from Mr. Tomaszewski in relation to the provision around amenity, which doesn't seem to come up because of the nature of the heritage area. And I think the case that was described was Sama, although, so perhaps you could go to that question first.
Thank you, Chair. The elected members would no doubt be familiar with the building envelope provisions, and if a building is outside the building envelope provisions, then the scheme takes you to the performance criteria, which looks at things like unreasonable loss of sunlight, overshadowing, visual impacts and those sorts of considerations. There's a unique feature of the scheme for that particular clause, which says that it says the acceptable solution doesn't apply if the property is in Heritage Precinct BP1, which this property is. There's a tribunal decision, which the Deputy Lord Mayor has referred to, called SAMA, which says that both the acceptable solution and the performance criteria don't apply. The heritage provisions apply instead. And so we've taken that interpretation with the preparation of our report, and the council as a model litigant has taken the view to this point that those provisions don't apply to the exclusion of the heritage assessment.
And so that's one interpretation, obviously, and there could be other interpretations should it be challenged.
Thank you, Chair. This issue has been raised by one of the representors. Having looked at that argument today, my personal opinion is that it's a weak argument. This issue ultimately boils down to statutory interpretation of how the scheme should be applied. There's been no changes, and the tribunal has already said that this is how it should be applied, that those two, both the acceptable solution and the performance criteria don't apply to the exclusion of the heritage provisions. One of the representors has argued that there have been some changes in the approach of the tribunal to the interpretation of acceptable solution and performance criteria. My personal view is that that relates to merits assessments rather than statutory interpretation.
And there was reference to Montgomery.
Yes, which is an example of the scenario where the extent to which the acceptable solution is relevant in the assessment of the performance criteria.
Because it's a different zone or different area.
Yes.
Councillor Coates.
Not so much a question, more just a discussion. But look, I think the council officers have done a great job in this instance. For someone who wasn't around for the previous application coming through, I think they've treated it as it ought to be treated, as a new application, as an individual one. However, they have obviously given us that background information. Ultimately, I think a lot of what we've discussed tonight has veered away from specifically this application more towards what is and isn't allowed under a scheme and in that area. And sometimes I think that the argument's backwards. It's when it's zoned to allow density of this type, that's when this argument needs to be had, not when the person who now owns it is actually trying to propose something that fits within that scheme. Look, I was listening to the points raised by Councillor Dada, and look, when it goes through in Councillor's report, I think it's pretty clear as to why the car parking is not such an issue. And I know it's something I always bang on about, how we don't have enough car parking, but they talk about this area, and the 6.9.5 I think lays it out fairly clear to me. So look, in this instance, dare I say it, but given what happened to the other application, we all know this may well end up in an appeals court anyway. But that said, I think given what's happened previously and given what we've heard tonight, ultimately I'm coming down to thinking that this does actually still comply with the scheme. The scheme hasn't changed. The point at which the argument had to be had as to what can be built on that site was when that site was zoned as to what it is now. Although yes, it doesn't meet every acceptable criteria, I think on a balance it does actually meet the performance criteria. And I was pleased to hear that the applicants had engaged in mediation in the first instance. And look, I think it is somewhat telling that when it came to choosing to appeal the decision to the Supreme Court, it was appealed based on the technicality of whether or not they could assess the visitor accommodation as opposed to the decision around heritage or built form. So in this instance, I think the onus going forward, if they do choose to appeal, ought to lie with the respondents as opposed to the applicant. And so look, I concur with the officer's report in this instance, and I'll be voting in favour of the officer's recommendation.
Thank you. Councillor Harvey?
Thanks, Chair. Yes, look, I'm also leaning towards approving this tonight. Some of the points, as Councillor Coates has mentioned, I think we're covered off quite well in the report with regard to access to public open space, car parking being in a highly walkable area. Waste is already a condition in the report, so that's covered. Managing waste, and the fact that it has been through a rigorous process already and has been approved previously convinces me that I think we should approve it again tonight, so I'll be voting in favour of it.
Thank you. Alderman Briscoe.
Thank you. Look, I hate to think this meeting would finish, or this item would finish, without making a comment about this is the entrance to Battery Point. I think the officers have summed up it very well about this area, and I'm just bear with me. I'm going to read out a couple of paragraphs because I think if this meeting leaves with the myth that this is affecting the entrance to Battery Point, it's a myth that has been created by. So I'd like to, by reading out the officer's summary or part of the summary, I think we should put that to the bid. So in summary, there's very little consistency in the development patterns in the streetscape or in the vicinity, varying from the heritage-listed Victorian Georgian cottage at 2 Hampton Road, a late 20th century house at 4 Hampton Road, and a 1920s house at 6 Hampton Road, and a mid to late 20th century apartment buildings, Empress Towers across the road. Elsewhere are parklands and reserve. In summary, this diverse and varied development pattern is not clearly articulated in the statement's significance for the precincts, and when considered that the proposed extension is a contained development and not dissimilar in form or major departure from the existing building, the height of the development is not obtrusive and does not distract from the pattern of development that is characteristic of the precincts. I think that, in summary, has summed up, it demolishes the perception that was trying to be created earlier that this affects the entrance to Battery Point.
Thank you. Any further discussion?
Thank you, Chair.
Councillor Dutta.
Thank you very much. I do take the points that have been made. At the end of the day, I am not here, it is my understanding, to look at application 1. That is not the issue. The issue for me is looking at this new application, which I call or identified exhibit number 2, which is the application is new. Hence, there is no overlap from the other application. For me, the point of importance is that those are the views expressed by council staff. You and I, as individually elected members, also have our views, and we can express those views and then accept whichever view we go along with the majority that will vote today. I have concerns with heritage issues. I have concern with parking. It has been stated that it is not such an issue. That is one view, but the other alternative view is that there is an issue of parking. That is the way I perceive it. And thirdly, the issue of close proximity hasn't been defined. It is a subjective interpretation, I think, in my view. If there is an objective definition to define close proximity, then that would be a different matter. And I think clause D1143P1 has not been satisfied in my view. Therefore, I will not be inclined to vote as far as the recommendation from the staff is concerned. Thank you.
Do you have a foreshadowed motion for refusal?
Not at this stage. I will, realizing that the majority of them are in favour, I would simply state my point that I would not be supporting it. That's all. Thank you.
Thank you. Lord Mayor? No other comments? Okay. Look, I too thank you for the discussion. I think it's this has been this required quite a in-depth discussion for various reasons. Partly because we didn't get to discuss it the first time round, but tonight we have, and I think we have looked at it from various perspectives. I thank Ms Abey for her interpretation. Some of those things in relation to parking parking access certainly concern me, and the issue around close proximity is an issue, and particularly amenity. It's quite strange that in a residential area the scheme is effectively silent on amenity when we're considering it under a heritage clause. So I find it very difficult to support this, and would have supported any foreshadowed motion for refusal. If there are no further comments, I'll put the item. I'll go round. Those in favour, can you raise your hands with the slightly amended version?
Aye.
So that's Alderman. Dave, do you want to go around the room?
Alderman Briscoe, Alderman Barakis, Councillor Coates and Councillor Harvey.
And those against?
The Deputy Lord Mayor and Councillor Dutta.
Okay, so that's carried 4 votes to 2, and that decision is final. Thank you very much for your deputations and time today. We go now to we'll go back to the agenda, item 7.1.1, which is 34 Davey Street, Hobart, and adjacent road reserve signage. Can I have somebody move that item?
Could I move it, Chair?
Thank you.
Just one question. Can we wait for the director to come back?
Oh, yes.
He's not in Queensland.
Thank you, Director. We're taking off without you.
And now I've got a question to the director.
All right, so we're on to 34 Davey Street, 7.1.1.
I'm just curious, Director, this is signage, why you would include, and I'm just thinking from a replacing it perspective, why you have signage that is proud of the place where it's stuck. Like it's on some of the sandstone columns or plinths or whatever you want to call them, the cornerstones and that sort of thing. But it seems that it protrudes beyond the sandstone, and I'm just wondering why you would design something that's really look for, I don't care, they can do it their way and replace it whenever they feel like it, but it just seems like it would be, hand grips to rip it off the wall.
Yeah, look,
from
I think it may well be easier to read for people, that it sort of angles up. That would be my only suggestion why they might have proposed it in that way, in that form. That there's a fair amount of detail there.
They needed a bigger sign.
Fine print. Instead of bending over necessarily.
I'm just concerned that it sticks out and you can pull it off from the side.
Yeah, I think it'll be anchored in there.
There's still hand grips is what I'm getting at. Anyway, don't worry about it too much. I'm happy to support it tonight.
Okay, further discussion?
Well, they all protrude.
No, but I thought it was because they wrap around.
Alderman Barakis has left the room, I think.
It's top on that side and side, yeah.
Oh, okay.
Because then you can look at it as you're coming down Murray Street and across.
Favour?
Oh, yeah.
Those in favour?
Sorry.
Aye.
Those against? Carried unanimously. 7.1.2, 34 Davey Street. Again, and this is the...
One, if you look like you're arching looking straight, yeah.
I missed that.
I'll open the item for discussion.
Move it.
Thank you, Councillor Harvey. Any discussion? I have a question, Director, in relation to like it'll be good for pedestrians and bike riders through that area, but I have a question just in relation to the path being a shared space. Is that a shared space? And able to be ridden, the footpath ridden on?
No. Look, I'm not sure whether the actual path itself is a path that is precluded from riding on. Normally, footpaths that are precluded from riding on need to be signposted. That the case in Davey Street, for example, is precluded from cycling on those footpaths where there's heavy pedestrianised traffic. I'm not quite sure whether this is within that classification, although it wouldn't surprise me because this is will be a heavily pedestrianised, utilised footpath. So similar to the rest of Murray Street heading into the shopping precincts.
And the development application mentions a bike lane going in on the other side of Murray Street, but that is not any plans available presently. Do you know the extent of that?
Yeah, look, I think there is scope, there is width for that to occur, but we haven't fully designed that side of the street at this point of time, other than we know there is sufficient width, certainly for downhill path if we wanted to. If we wanted a counterflow lane, well, I suppose the view is that cycling movements back into the city are much more gradient friendly from Elizabeth Street and Salamanca Place, as opposed to the much more steeper Murray Street. And counterflowing to the traffic movement as well, which adds complications.
All right, further discussion? Thank you. Councillor Harvey?
So I'm slightly more confused now. From a cycling pedestrian perspective, and the plans were hard to follow, looking at it on a computer screen. Is there any chance we could put it on the big screen so we can talk through it? Because I see obstructions on both sides of the street. We're talking about, bikeways and things. We've got a platform outside the cafe, Darchi and Darchi, which would exclude any downhill bikeway, which is not, I don't know whether we want that, but being a one-way street, is there room for a counter, what do you call it, a contraflow bike lane on the right side going down the hill? And then you've got trees occupying half the road anyway. So has this been looked at by the what's it called, the access committee?
No, not the active transport.
Active transport committee, I should say.
No, it hasn't. But we would argue, the officers would argue that having a counterflow lane going uphill in Murray Street to take you into a three-lane.
Heading
into that direction is probably not the best allocation of bicycle space when you've got alternatives either side in both Elizabeth and Salamanca that are much more gradient friendly for bicycle movement. If you and in terms of a downhill bicycle path, you've got gradient in your favour anyway, so you're moving at that vehicle speed anyway in that direction. So, but there would be sufficient space if you wanted to have a 1 metre wide bicycle lane on the other side, on the executive building side, is our understanding.
A downhill
bicycle lane, yeah.
Which would go around the platform.
Go around the platform, yeah.
Right, no, I think your first part was the best bit, yeah.
Just to clarify, isn't it the drop-off point anyway in the car park on the Davey Street for the new hotel? So having a bicycle counterflow there wouldn't work anyway. Because
that's right. Yeah, you'd have to have it on the other side.
You'd have to have it on the other side.
Yeah.
And for the 3 bicycles that use Murray Street, probably doesn't work.
Any further contributions? No? Okay, I'll put the motion. Those in favour? Aye. Those against? Item is carried.
Thought you were going to be a bike champion this year, or last year.
Just because
Item 7 point...
professional ideas, not necessarily
Talk about it though.
Excuse me, can we get on with the agenda, please? Item 7.2.2, which we're back to the Hobart Interim Planning Scheme. So 52 Melville Street, this is the Hillsong application. I'll open the item for discussion.
I'll move it for the purpose of discussion. I think it's good to see the building get reborn again. So I'm sorry.
I knew you had a secret.
I'm pleased to see that it will be renovated and a new life will be risen from the premise.
Thanks. Further discussion or comments? Lord Mayor? No?
Oh, just I guess it's not really, no, it's not relevant to planning, so I think I'll leave it to another discussion, probably in city infrastructure. Thanks.
Director, could you just explain what sort of, given there are other existing businesses, and these were brought up in the representations, what sort of noise attenuation may there be?
The applicant does indicate a willingness to do some work in that regards, but it is a commercial precinct.
I know, but yeah,
and
there will be noise coming out of this building. Yeah.
As there, so if you just bear with me. So it's the building sited as specified under 7.2. I think the building sited in the central business zone and is not close proximity to a residential zone. Therefore, there are no requirements for specific operating hours or noise attenuation measures. While the applicant has not specified any hours of operation, they have responded that as part of their design process and future works, they have engaged the services of an acoustic engineer to provide advice and solutions to minimise any noise impact the development may have on the surrounding properties. And of course, there is the IMCA provisions, which does afford ability to take action if there's a statutory nuisance or environmental nuisance.
Yeah. Okay. Yep. Yeah. No, I was asking specifically because I know it's not a residential area in regard to other commercial uses such as speech pathology. In relation to the lighting for the sign at the front, it's stipulated that shouldn't occur between 11 p.m. and 6 a.m. Is there any way we can reduce those hours? Because, I mean, is anybody going to be going past 11 o'clock and thinking, oh, better go in at 11 o'clock? I mean, is there ways of just reducing or conditioning that light? And signage?
Yeah, through your chair. Clearly we've proposed what we think is reasonable hours for the control of that illuminated sign. If committee were of the mind to impose greater restrictions,
I don't know if the mover would be prepared to reduce that chimes, maybe from a reasonable 8 o'clock till 10 o'clock?
Looking at the wrong person.
Oh. Councillor Harvey?
No. Look, I don't know why. It's going to be turned off at 11. How bright is it? So what's the... Is it going to be a very bright sign? It doesn't project its light, it's just a glowing sign? And it's not going to project into the window, is it, of the neighbours, or...?
Page 689 suggests that it might be directly opposite, possibly a residential facility, or it might be a visitor accommodation.
All right, well look, I'm happy to go for 10. We can save an hour of energy on the sign as well. So there you go, part of our climate mitigation strategy. So I'm happy to make that 10 o'clock rather than 11 o'clock. Yep.
7 till 10 or 6 till 10?
10 o'clock at night,
yep,
till 7 in the morning. What's it currently? 10 till 6?
6 till 11. 11 till 6.
11 at night till 6 in the morning. So from 10 at night until 6 in the morning, or you're suggesting 7 in the morning? Is that during daylight savings, or? I don't mind.
I just think, you know, like a sign, and a sign is there to attract passers-by. There's more likely to be people passing by in the hours of 7, between the hours of 7 and
I'm
10.
happy to make it 10 to 7.
Right, thank you. Further discussion? Right, if not, I'll put the motion with slight amendment. Those in favour?
Aye.
Aye. Those against? Items carried. Item 7.2.3, which is 109 to 113 Liverpool Street. This is another sign, I think, and it's for refusal. Can I have somebody move that, please?
Happy to move that as well.
Thank you. Councillor Harvey, discussion?
So that's been rejected by both the Heritage Council,
and
our heritage officers,
we
so we're obliged to support it.
simpatico this time. Any discussion? No discussion. I'll put that. Those in favour?
Aye.
Those against? Motion's carried unanimously. Item 7.2.4 is 326 Strickland Avenue, which is for a dwelling and a removal of an E-globulus.
Happy to move that.
Thank you,
Chair.
Alderman Briscoe. Any discussion? There were no representations, Director, in relation to this, but is there, I mean, it seems to suggest there will be some impact from overshadowing on the next door house.
Yeah, I'm just looking at the descriptions. So clearly the officer's assessment of the proposal is that it satisfies the performance criteria on their assessment and their subsequent recommendations.
And in relation to the E-globulus, it's kind of best if they don't get removed. What's your understanding of its significance in that stand?
Yeah, well, look, again, the officers have concluded that it's an acceptable in this instance. So again, I'll be guided by their assessment, their qualified assessment in this instance.
Can we condition or advise for replanting, or is that not advised? What's the suggestion in relation to that?
Yeah, look, again, it's just a question of suitability of that type of trees within proximity to houses. I would we could certainly include that. The site is a reasonably sized lot, so there might be other alternative locations for that. So it might be something that we could include as an advice.
Is the mover happy to have that as advice?
The advice is going.
So the advice is to suggest a planting replacement globulus in a place that might be suitable on the property.
They're very fast growing, and should be nowhere near a residence, but yeah, if it's advice, then if the Tasmanian Fire Service don't agree with that, they'll have a different view about it. So with advice, I'm happy to include it in.
Thank you. Okay. Any further discussion? If not, I'll put the motion moved by Alderman Briscoe with that advice clause added. Those in favour? Those against? Items carried. Now we come to report 7.3.1. Oh, sorry, no, it's 7.3, which is the amendment PSA 22, which is relates to Lefroy Street car park. Director, do you want to just discuss this, or introduce this, please?
Yeah, we have Mr. Matt Clark from JMG Consulting.
Hello, Mr. Clark. I wondered who you were, what you were here for.
Yeah, who, given this was a council-initiated application, we, as a practice on complex ones, we will refer these out for independent consultant to review. Mr. Clark has served that purpose and undertaken an assessment of the application, which was fundamentally for the rezoning to general business of the rear portion of 321 to 323A Elizabeth Street, which is currently zoned in a residential. So the basically the conclusion has been from JMG is that a rezoning from inner residential to general general business was not necessarily an appropriate course of action, but rather a specific purpose variation to the use table for the inner residential zone to allow for car parking to be accommodated, both on these on that specific site or those specific site, but also the adjacent Lefroy Street car park, which would require to be used for vehicle access to this car parking facility. So that normally those sort of specific purpose variations are not normally accommodated by the Planning Commission, but there was some conversation with the Planning Commission and in relation to this matter, and they were a little bit more comfortable under the circumstances to consider such a specific purpose variation.
Thank you. Are there any questions?
Happy to move that, Chair.
To move that, okay, thank you.
So Chair, so
Councillor
the advantage is for that space, it can now be used legally as a car park, commercial car park.
Chair, that's the intention as a discretionary use. So it would be notified, and all the existing codes, particularly waterways and coastal protection codes, would still apply. All those provisions would still apply under the proposed scheme amendment. So, yep.
So this is actually required in order to facilitate.
Exactly.
Yep.
Alderman Barakis?
So this would effectively allow us to continue as what we, the decision of council, I can't remember the day that, I think it was the end of 2019 or beginning of 2020 that this was done, but that this will effectively get that ball rolling.
That's correct. It will accommodate that as a formal planning application, and we can consider, the council can consider.
Chair, can I just
Yes.
ask a question? Yeah, I guess the cost of this is obviously piling up as we're paying rent, aren't we, still, while we wait to see whether we can actually even do this. Is that how much have we paid so far, and much longer do you think we're going to be paying rent for it's sort of like holding rent, really, isn't it?
Lord Mayor, I don't think that's really a planning issue. It might have to be a question of the general manager or at finance. I don't think Mr. Noy can't really help you with that one, so you might need to hold it over till tomorrow night. This will go to full council on Wednesday the 27th, so there might be time for questions in relation to that. Are there any other questions? Anybody else have a question? So all the titles are in place for this to, like, they're all lining up? Because I wasn't sure what the yellow on the title, there was a yellow triangle which was highlighted. What was that in relation to?
That was a piece of land that didn't necessarily have a recognised owner.
Oh, I see.
So that occurs from time to time, and we understand we'll consider scheme amendments relating to those parcels.
Okay.
Those
All right,
parcels
thank you.
of land.
Is there anything that you wanted to add since you've been sitting there waiting for this item?
Neil's certainly covered most of it. Certainly the main reason we departed to a site-specific qualification over the general business rezoning was that the general business rezoning, both under the current scheme but also the Tasmanian planning scheme, brings in a lot of other rights that would go with the land that wouldn't be subject to council. So potentially the owner could say, well, thanks very much, and I'll go and develop a so it's for that, largely for that reason, and that this area is outside the heritage precinct of the Hobart area there, which has to go down this site-specific route, which enabled us to tidy up the issue with the existing car park as well.
And when it goes to exhibition, should it be approved Wednesday week, will the neighbours who are in the housing commission places, will they be notified directly in relation to that?
Normally if it involves a specific location, we would be notifying immediate neighbours. That's my understanding.
Yeah, they're tenants of the government, I suppose, as housing commission people. But
owners and occupiers.
Owners and occupiers, okay, because I think that's really important, because they're going to be mostly impacted on any such future change, future use.
Unless Mr. Clark would like to add anything?
No, that's my understanding of council's. It's not a statutory requirement, but it's I understand that's council's policy. Yeah.
And there's only going to be access from Lefroy Street?
Yes.
Okay, thank you. Alderman Briscoe, did you?
Oh yeah, look, we've already made the decision to lease this land for a car park with access from Lefroy Street. So to me, the decision was made 2 years ago.
Well, it's still got to be approved by the RPDC, doesn't it?
Oh, what I'm saying is that we didn't have any objections, I don't believe, when it came before council. But anyway, let's see what happens.
Yeah, has it?
No, not as a formal planning application.
Yeah. Okay, so it's got to go through a bit of public scrutiny as well. Okay, so I'll put the motion. Those in favour?
Aye.
Those against? Item is carried. Go now to reports. Mr. Noy, thank you very much. This is 8.1 Southern Tasmanian Regional Land Use Strategy Proposed Review Process and Draft New Policy and a submission. Mr. Noy, do you want to just introduce this, please?
Yeah, the Minister recently wrote to us outlining a roadmap for the review of the Southern Tasmanian Regional Land Use Strategy. This strategy was formally endorsed, I think, around 2011. And it's time for review. And the Minister has also outlined a proposed new interim policy relating to urban zoning beyond the urban growth boundary to accommodate modest expansions of the urban growth boundary where it's appropriate to do so, without necessarily amending the regional land use strategy, formally amending the regional land use strategy. Now, we've had a couple of instances where we've had to amend the regional land use strategy to accommodate zoning changes. and it can be a fairly arduous exercise. The interim policy is simply to set out specific circumstances where a fully fledged amendment to the regional land use strategy is not necessary to accommodate the expansion of the urban growth boundary. In coming back to the review of the regional land use strategy, there is a diagram that's attached or outlined that sets out the roadmap for the review, and it's fairly detailed. There's a metropolitan plan that's being worked through as part of the Greater Hobart Act. There are a number of Tasmanian planning policies that are proposed to be adopted in some form, and there's also some regional planning discussion papers also being proposed as part of that review process. So that sort of spells it out over probably a 2 or 3 year period. In relation to the interim planning policy, we've raised some potential scope for improvements in relation to that policy. We don't want to, and part of the issue that currently exists with the regional land use strategy is the urban growth boundary, is that there is significant land within that urban growth boundary that developers are land banking and not developing for various reasons. And we don't want a situation where we are allowing that urban growth boundary to be expanded simply for developers to then land bank that expansion. We think that there should be a requirement, if they are going to expand that urban growth boundary for whatever reason, that they should there should be an onus on those developers to then proceed to develop that land. We think that this shortcut mechanism should be spatially constrained, in terms of the area that should go through that shortcut process to 2 hectares. We think that that's a reasonable size correction of that boundary. We think anything over that is should go through the much more lengthy process. We think that the policy should only apply to those the metropolitan area, not necessarily outer townships, because we know that those expansion of those outer townships can have beyond the nominated urban growth boundary, can have particular servicing implications, both physical infrastructure in terms of access into the metropolitan area, but also social services and schools and the like. Whereas expansion of the existing metropolitan area, you would imagine, is able to be accommodated more readily within the existing service infrastructure that exists within those metropolitan areas. I think that they are the main points that I want to touch on in my.
Yep. Thanks for your summary. All right, Councillor Harvey.
So, I haven't read the Minister's letter thoroughly enough, so I'm just curious whether this review also, it's the Southern Tasmanian Regional Land Use Strategy, it's not just the urban growth boundary?
That's correct. It's a much more comprehensive exercise than just the urban growth boundary. There will be, much broader infrastructure issues at play.
And something I'd like looked at as well, and you might like to consider including this. I'm not sure what the words are because I haven't had enough time to think about it thoroughly. but from a land banking perspective, I've heard that a lot of the land along the rail corridor has been snapped up. A lot of it went onto the market a few years ago, and I understand a lot of it's been snapped up, and it's banked, and it won't be developed for potentially a couple of decades, I understand, as the developers work their way through their other properties. Is there a way of reviewing the land along that corridor, because this was strategically part of the plan to get that corridor developed and growing, which would support potentially a light rail at some point in time? But I think one of the focuses for the metropolitan areas, for Hobart, Glenorchy, was that corridor, and I'm concerned that we won't see the development along that corridor that was intended, because the properties won't be developed for a long time. Is there any way of reviewing that as well?
Yeah, look, a very good question, and it's probably a question for Glenorchy City Council. Are they the jurisdiction that has control over the majority of that corridor? But is it an issue for the regional land use strategy? Look, I think that the strategy as it currently exists has a policy position of 50% infill target, and clearly that corridor has implications meeting that target, and I'm sure that will be considered as part of the regional land use strategy, as it would be by Glenorchy City Council as part of their local provision schedule.
But we also went through an expensive exercise, I think, between Glenorchy and Hobart to look at potential development sites along the corridor as well. So, and there's a vast body of work that's been done along these lines.
Would it be your desire to perhaps write and flag that?
Well, I think...
Ask the Lord Mayor to write to...
well, maybe it needs to be part of this submission as well.
Yeah, look, I think we'd want to, I suppose, gain a little bit better understanding of the position of Glenorchy City Council that is probably much more across this issue without necessarily raising it at this point in time with the Minister. I think that it's within Glenorchy's City Council's powers to pursue that matter of zoning. The issue of land banking in that location is an interesting issue. Normally, land banking, we have raised the concerns has been around greenfield sites, not about infill sites. So I think in short, I think we'd need to maybe better understand from Glenorchy if there is an issue and what it is.
Maybe then the question later in the episode.
It's, I mean, this submission goes in before the 5th of February, so there may be time to have an informal discussion with Glenorchy between now and then. Alderman Briscoe?
Yeah, look, whilst we like to think that we are looking at the bigger picture, we are the City of Hobart, and the urban growth corridor boundary, we have very limited extent, according to the report, to extend that, haven't we? There's a few minor things that we could move it slightly, but because we're constrained by the mountain and the river, it's not going to affect us that much in looking at City of Hobart land use. That's correct?
Look, from a purely Hobart City Council planning perspective, the options for us to expand our urban growth boundary are limited. Yeah. We're physically constrained. But clearly, expansion on the periphery does have, I suppose, access and, I suppose, servicing implications for those locations. So we would argue to some degree that, and that's the whole objective of the urban growth boundary, is to plan that growth appropriately to ensure that it's serviced appropriately and we're not inefficiently creating inappropriate growth that would have to be further serviced inefficiently.
Yeah. In my mind, we've already lost it. Sorell is the fastest growing municipality in Tasmania, and infrastructure, highway, etc., is inadequate. However, there might be greater moves. The understanding of from COVID flow-ons is people like a little bit of space around themselves. They don't want to be in dense urban areas, and also we're having a movement of people away from cities into regional areas. So I think we've got to factor, it's not us to factor that in, but it may be that creating more growth around regional centres in southern Tasmania may be the way to go. Before it was urban infill, but now, because of all those factors, that maybe a long-term strategy is to start putting employment opportunities in those regions so people don't have to get in their cars to come to Hobart. So all I can say is it's a moving feast, and we haven't got much say in it because we haven't got any land to extend the boundary. We can just say it would be nice to have more infill, but we haven't got many opportunities to infill, except perhaps North Hobart area. There's not very many places that I can think of, because most people don't like living in units. We might have a unit growth at the moment in Hobart, but most people in Hobart don't like living in units because it's like flat living. They want a bit of space around them, and how to get space around them if you aren't lucky enough to have a property already in Hobart is to move out into the outlying areas like Kingston, New Norfolk, Sorell, Clarence and so on. So I think what you've written there is fine with me. I agree with it, but not that we're going to have much impact on it at all.
Thanks, Alderman Briscoe. Councillor Dutta, did you have anything to add? Lord Mayor?
Yeah, a couple of comments. Thanks, the submission looks really good. There's a couple of typos. It refers to 2020 in one case, but I think there's a really important thing that we need to say up front, and that is that Hobart, because this isn't, we are part of Greater Hobart, and expansions of dormitory suburbs that are dependent on private vehicles, unless sort of good public transport follows, and unless there is the kind of really dramatic change in workplace arrangements that Alderman Briscoe is talking about. I think it's really important to say quite up front that Hobart, as the CBD host and centre of the region, is impacted by the growth of car-dependent dormitory suburbs, and it does impact on the efficiency of the city, congestion, loss of amenity, and I guess the productivity of the city in terms of people's ability to get around. And so we do have, as it is more than just what happens within the City of Hobart boundaries, because ultimately we're the honeypot that people are coming to, and so it's really important that we do highlight that that we have an interest in ensuring that this growth boundary doesn't go too dramatically. I think you've already said that you're planning to put into the submission that we conditionally are very supportive, but it is based on this being about minor adjustments to the urban growth boundary, that the criteria for these adjustments needs to be quite tight and defined, and that there is a total cap or threshold. And that is really important, not just for sensible urban planning and us not having a lot of impacts on the city with lots of, there's quite a lot of evidence to show that the more you spread out, the more the infrastructure budget is spread thinner and thinner for people, and obviously servicing things like water and public transport just becomes such a really, really difficult thing to fund. So I think it's also worth us just pointing out somewhere in the submission that the current urban growth boundary does still allow for quite significant amounts of development that hasn't been utilised yet, and I don't know why that is. I don't have that analysis, but in terms of adjustments, in some ways it's too early. I mean, I think sensible small adjustments is what we're supporting, and I'm it has to be practical. But the big picture is, and we should just highlight the fact that there is still a lot of the area that was identified for growth within the current boundary is still there, and for property owners who've got that land, it is better that we focus on that land first before we start looking for more and more land outside that boundary, because there's still, I think, about 20 years of growth still based on current levels within the current urban growth boundary. So yeah, I think just really highlighting those some of those bigger picture issues about how it can impact us as a CBD. Just saying that our support is it's supportive, but it is conditional on the government ensuring. It's cautious and conditional on the government ensuring that the criteria is tight, that it's focused on those properties that are already that are adjacent to the urban growth boundary, that there is that there's some modelling to ensure that we don't unwittingly unleash a lot of additional new spots on the edge. That's before we actually review the the Southern Land Use Strategy, because then it would really be planning through sort of by creep rather than the strategic planning, which is what I think is envisaged with the review of the Southern Land Use Strategy. So with those kind of tweaks, I think it's a good submission. But
thank you.
No, I think that's probably a similar message that all the other Greater Hobart councils will probably have a similar sort of message, apart from the issue around the impact on the CBD.
Yep, thank you. And so you'll pass those words on to Mr. Noy, will you? Mm-hmm. Yep, thank you. Mr. Noy, can you do you know what the ratio is currently? With the split should be about 50-50 with infill housing. What's the reality?
Yeah, no, it's
80-20 still.
It's a lot less than that. I don't have the exact figure, but certainly the housing mix. We've got one of the we have the highest, I suppose, single dwelling, separated dwelling. As compared to other forms of housing in the country. So I think it's over 85% single detached dwellings. And part of the intent is to provide a greater mix of housing types.
All right, thank you. If there's no further discussion, everybody's had their say. Okay, so I'll put the motion.
No, I haven't got to move yet.
I think Alderman Baracus, didn't he?
I'm happy to move the motion as on the agenda.
Thank you, Alderman Baracus. Those in favour?
Aye.
Those against? Items carried. Thank you. 8.2 is monthly building statistics. Somebody move that, please. Thank you. Those in favour?
Aye.
Those against? Items carried. Delegated decision report. So this is the report of those that have been decided.
So moved. Yeah.
Thank you, Alderman Briscoe. Those in favour?
Aye.
Those against? Items carried. 8.4 is the advertising report, and Mr. Noy or Ms. Aby, can you just point out any particular ones which we should be looking at, please?
Thank you, Deputy Lord Mayor. There aren't any particularly significant applications. There are a number where there's a proposal that driveways extend into the road reservation, for example. There's one that, on the first page which is a proposal for visitor accommodation, which has raised a number of frustrated members within the body corporate. Otherwise, the applications aren't particularly significant. Oh, sorry. I'll forget about that one because I've got a conflict. The Newtown Hospital is, I believe it's on advertising at the moment. So that will be before you, probably not the next round, but the one after that, I'd say.
And are there any of these listed which will not make it to either committee or council?
There are a number of expiry dates which are listed, which take place before the next council meeting. Having spoken to the relevant officers, each of those has an extension bar Fisher Avenue, which is we're waiting for a response for that.
Is that council land or is that a private?
It's a proposal relating to private land which extends the driveway and an associated proposal extends into the road reservation.
Yep, and 10 Bimberdine Courts here, and that was...
Correct, that one has been decided, as you know.
That had to be decided at officer delegation, because we didn't get an extension, or we had 3 representations instead of 2. All right, but otherwise there are no others that haven't had an extension that you're aware of. All right, thank you. All right, I think Councillor Coates, did you move that one?
I can. I'll move to be ready accepted. Yes.
Go on. Go on, do it.
Those in favour?
Aye.
Those against? Items carried.
My record says strong.
Item 9 is responses to questions without notice.
I'll move those.
Yep, thank you, Alderman Briscoe. Those in favour? Those against? Items carried. There's quite a number of there. We're up to item 10, which is questions without notice. Does anybody have any questions without notice?
I have a question without notice.
Thank you.
Start with Alderman Briscoe.
Thank you. I think I've got 2 if I can get organised here. Lyndon Dadswell, who is one of Australia's most significant sculptors, had a sculpture that was in the old Commonwealth Bank in Elizabeth Street, and the bas relief sculpture there has been removed. Why wasn't that heritage listed? Because it was a significant sculpture that went round the whole of that big void of the Commonwealth Bank. Why wasn't it listed? In interests of we're a heritage city, and there was one of Australia's most significant sculptures that were removed, and why wasn't it listed by the council? So that's the first question. And the second part of it is, where has the sculptures gone? And another question, which is on a different topic, is I did note that there's an appeal against the Parliament Square access by disability access. What stage is that at?
Sure, I'll take that one.
Thank you.
Turner, can you answer that? Do you want to come to a microphone, please?
That appeal doesn't involve the council, but my understanding is that the disability advocates were successful at the full court, and there's an appeal to the High Court pending.
Right.
Right.
That might answer your question.
Oh, well, it probably the corollary to that question is the implications for the new building approval if it's upheld in the, if the appeal is dismissed in the High Court, then there would have to be a new building application, wouldn't to get disability access?
No, because my understanding of the appeal is my understanding is that the Parliament Square approval complies with the Building Code of Australia, but it doesn't comply with the some other national provisions, and how they relate together. It's potentially that they would need to make some modifications, but I don't think it would need an approval if it was upheld at the High Court.
Can council be kept informed of the developments there?
Thank you. Right, Councillor Harvey.
Thanks, Chair. My question relates to reports previously completed with regard to potential development sites along the corridor, along the transport, or the, what do we call it now? The
rail corridor.
The rail corridor. And if any action or further advancement of that, the recommendations of that report have gone anywhere. Something along those lines.
I'll get that in writing and I'll take it on notice.
You want me to say it again, or you got it?
It's on tape.
So you can write it down and send it to Dave.
So we really get what you...
Okay. Yep, thank you.
I thought you were putting your hand up, Rachel. You don't want to ask a question? No,
What's
you're
your question,
bidding.
Rachel?
Councillor Dutton, did you have a question without notice?
Two questions, Chair. Question number one, just wanted to know what is the state of play with regards to the cable car application, one. And number two, with regards to that height report that we're supposed to get, wondering what's the progress with that particular report?
Maybe Ms Turner can respond to the cable car matter. Yeah, if it's current legal proceedings, it probably should be asked in closed.
All right, we'll seek an answer in closed. And the second question, Mr. Noy?
Yeah, look, a brief in relation to the height matter. A brief has been drafted for a consultant to undertake the economic, social, environmental impacts of the various building form options. And we are hopeful of having that commissioned and completed in time for a report back to Council in May.
Thank you very much.
Councillor Coates.
Look, this may be one that you can't answer now, but only because it came to mind as we were having the meeting earlier. But the question is, really, it's one about the risk. When we're sitting as a planning authority, we had one of the voting members connecting online, but then saying that they weren't able to hear the evidence given. And my question is, I know that under the Acts, obviously, we can meet remotely, but I guess it's one thing when we're all sitting in the same room hearing the same information, but if some of us are hearing some and some aren't quite getting all of it, my question is there a, I guess like from a more council legal point of view, is there a risk in us continuing to do the hybrid model in terms of the voting members?
You might have to refer that to the governance.
Yeah, I can ask it tomorrow if that's more appropriate. Yeah.
Yes.
Yep.
Yep. We can refer that to the governance committee if you'd like to.
Yep.
Yep. Thank you. Or you could ask it and have it written down and just give it to to them. Okay. Any further questions? I have one question, and it might get referred to city infrastructure, but I'll ask it because it's relating to an item that we discussed today. In relation to parking in Battery Point, how many parking permits are issued and how does that correlate to the number of parks available? So that might go to city infrastructure.
You're talking resident car park?
Residential.
Parking permits?
Residential parking permits, yes.
Right. Yeah, I'll take that one on notice and refer it.
Okay, thank you. All right, thank you. I think we can go to item 11, which is to close this portion of the meeting. Can I have somebody that move that?
Move
Thank
that
you.
we close the open and open
Varadkar.
closed.
Those in favour? Those against? The item's carried.
Aye.
And we now say goodbye to the public because we're just about to go into closed meeting. So if you